thought you said that it wouldn't apply in particularly egregious cases. Did I mishear that?
That's correct. I mean, our frontline position.
Correct that I didn't, but
correct that you didn't.
I misheard it, or that.
Our frontline position is that there should not be an exception for even egregious miscarriage of justice, because that petitioner has argued this case based in contract doctrine, and we don't think there's a basis in contract doctrine for that. If this court goes the route of wanting to have a miscarriage exception for reasons other than contract law, maybe some kind of, sort of federal common law policy making or constitutional, we would very strongly urge this court to define whatever that exception would be very narrowly and to make clear it doesn't apply here.
So all of the hypotheticals that Ms. Blatt presented us, you're comfortable defending all of those?
Our frontline position, yes, is that the appeal waiver is enforceable.
Frontline position.
Yeah, sure.
To me, that conveys the notion that you're ready to retreat.
No, I'm not ready to retreat. I'm not ready to retreat. Our position is that the appeal waiver is enforceable.
So the order that you only make your wife pregnant, or what all the other examples you say, that's fine.
Yes, our position is that that's enforceable, and I recognize that sounds like a very harsh result, but I don't think it's a real-world concern that this.
A racist sentencing judge.
Again, our position is that it is enforceable. There are a few.
A sexist sentencing judge?
Yes.
Someone who is biased against religious minorities?
Yes, the appeal waiver is enforceable.
All of that stands. Because
the point is that at the time that we're deciding whether to enforce the appeal waiver, all we have is a claim that there has been this particular type of error, and what the defendant has given up as part of the bargain is the right to bring that claim.
Sort of disrepute on the federal judiciary that Judge Posner talked about. If you held a trial with 12 orangutans, was his example, that would have to be resolved. And I think we would all agree with that, right? But here you say any sentencing error of any kind.
So to be clear, an appeal waiver is not an agreement to receive an unlawful sentence. You couldn't agree to receive trial by 12 orangutans. That would be an unlawful bargain. It is an agreement that the final decision maker, it's an agreement that the final decision maker on your sentence will be a district court rather than a court of appeals.
It's a district court who says, I'm going to let an orangutan pick a sentence out of a hat.
Well, again, and
you would say no right to appeal that.
The district court remains oath-bound. It is a bargain that at the time you're entering into it, all you're agreeing to is that the district court will be the final decision maker. Yeah. That is not a bargain against the law. The law already tolerates the possibility of even egregious sentences going unreviewed because it has given defendants the choice whether to bring an appeal or not. If the law did not tolerate that, we would have a system of automatic appeals, as many states do, for example, for capital cases.
Can you talk about